All right, let's jump right in. If you've got an international law exam on the horizon, you already know that figuring out where the law actually comes from is literally half the battle. So in this explainer, we're going to systematically break down that essential framework. We're translating all that heavy academic jurisprudence into a streamlined, highly effective guide that you can use to absolutely ace your essays and impress your examiners.
Here is our roadmap for today. Section 1, Defining International Law. Section 2, Article 38 and the course sources. Section 3, Subsidiary and Contemporary Sources. And Section 4, Landmark Cases and Exam Application.
So here's the ultimate jurisprudence puzzle you have to solve in your exams. Where does international law actually come from? Domestic law is pretty easy to spot. You've got a centralized legislature writing the rules and a police force enforcing them. But on the global stage, there's no world parliament. There's no global COP. So without a centralized global legislature, we have to look really closely at specific sources to find any kind of binding authority.
Section 1. Defining International Law. The Rules of the Global Stage.
Okay, starting with the absolute basics. International law regulates the conduct, rights, and duties of sovereign states and international organizations. Now here is a massive exam tip for you. Always contrast this with municipal law. Domestic law is vertical, right? It comes top-down from a sovereign, but international law operates horizontally. It relies entirely on cooperation, sovereign equality, and most importantly, state consent.
Moving right along to Section 2, Article 38, the core sources, the statutory basis.
The second you see an exam question about sources of law, your brain needs to immediately go to Article 38, Paragraph 1 of the ICJ statute. Literally make it your first stop. It is the single most authoritative statement on where international law comes from. Now, jurists divide these up into primary formal sources, that's your treaties, your custom, and your general principles, and subsidiary evidentiary sources, which are your judicial decisions and juristic teachings. Let's break those primary ones down first.
First up are treaties, or international conventions. These are, by far, the most prolific primary source of modern international law. And examiners absolutely love it when you distinguish between the two main types. On one hand, you have lawmaking treaties, like the UN Charter, which are these massive, universal framework agreements that bind tons of states to general norms. On the other hand, you have treaty contracts. These are much narrower, usually just bilateral agreements between two states, like drawing a border. Oh, and the golden rule you absolutely must drop in your exam for guaranteed points, pacta sunt servanda. It means agreements entered into in good faith must be strictly observed.
Next up is customary international law. If you're tackling an essay on custom, you have to explicitly analyze two mandatory steps. If you miss either one, your whole custom argument completely fails. Step 1 is the objective element, state practice. We're talking about constant, uniform behavior by a significant majority of states over time. Step 2 is the subjective element, opinio juris. This is the psychological belief that states are doing the practice because they legally have to, not just out of politeness or diplomatic courtesy. Remember, you need both parts.
All right, so what happens when treaties and custom just leave a gap? You end up with a legal deadlock, known as non-lique. To fix that, the ICJ turns to the third primary source, general principles of law. These are basic legal principles recognized across domestic legal systems all over the world. A few crucial examples for your notes. Res judicata, which means a final decision can't just be reopened between the same parties. Audi alteram partem, meaning no state should be condemned without being heard. And estipal, where a state can't suddenly assert facts that totally contradict its own previous official stance.
Let's hit into Section 3, Subsidiary and Contemporary Sources, beyond traditional frameworks.
Okay, first, let's look at the subsidiary sources under Article 38, judicial decisions and juristic works. Now, here's a detail that trips up a lot of students. International law does not follow strict binding judicial precedent. There is no stare decisis under Article 59 of the ICJ statute. Court judgments and the writings of highly qualified experts don't actually create the law. Instead, they function as secondary evidence to help verify and interpret the rules that already exist.
Now I want you to sear this next Latin term right into your brain. Just cogents, or peremptory norms. This is literally the absolute highest level of contemporary international law. We're talking about fundamental norms accepted by the entire global community from which no derogation is ever permitted. Think absolute prohibitions against aggressive war, genocide, slavery, and torture. If any treaty or state action conflicts with a just cogens norm, it is automatically null, void, and totally illegal from the very start. No exceptions.
Closely tied to that is another massive concept, obligations erga omnes. While your average treaty is strictly bilateral, erga omnes obligations are duties owed to the entire international community as a whole. This is a total game changer for international legal standing, because the legal interests at stake here are so vital to the global order, like protecting fundamental human rights. Literally every single state has the legal standing to demand enforcement, even if they weren't the ones directly harmed by the breach. Before we jump to the case law, do not forget to drop these alternative, contemporary sources into your exams. First, UN General Assembly resolutions. While they aren't automatically binding, they can provide massive evidence of custom. Then you've got soft law. These are non-legally binding guidelines, like the Rio Declaration, which can eventually harden into binding custom over time. And finally, unilateral acts. If a state official makes a formal public declaration with a clear intent to be bound, that actually carries immense practical and legal weight.
All right, the final stretch, Section 4, Landmark Cases and Exam Application, the cheat sheet.
Let's kick off the case law with the North Sea continental shelf cases, involving Germany, Denmark, and the Netherlands. So Germany opposed this equidistance treaty rule that it had never actually ratified, but the other nations argued, hey, this rule has become binding custom anyway, while the ICJ sided with Germany. This case is your absolute go-to authority for proving customary law. It's set in stone that a custom requires widespread, virtually uniform state practice plus a really clear showing of opinio juris. Since the belief in a legal obligation was missing here, the custom completely failed.
Next up is the Paquete Habana case. Picture this. During the Spanish-American War, U.S. gunboats seized these civilian Spanish fishing vessels. The U.S. government argued, well, there's no explicit treaty protecting them, so they are valid prizes of war. But the U.S. Supreme Court looked back at centuries of uniform maritime practice across Europe and America and actually reversed the capture. Cite this in your essays to demonstrate exactly how unwritten customary law can be located and applied directly as a primary source of law by a domestic court.
Then we have the SS Wimbledon case. Germany tried to block an English ship from passing through the Kiel Canal, arguing that its internal sovereign duties as a neutral nation during a war took priority over a free passage provision in the Treaty of Versailles. The Permanent Court of International Justice looked at that and said, absolutely not. This is the perfect case to cite when you need to discuss the supremacy of international treaties. Entering a treaty is an exercise of sovereignty, and under Pacta sunt servanda, valid treaty rules take supreme priority over conflicting domestic arguments.
Moving on to the Barcelona traction case. Belgium tried to sue Spain over the bankruptcy of a legally Canadian company, just because Belgian shareholders were the ones hurt. Spain argued that Belgium simply had no standing to sue. Now, while the ICJ actually ruled in favor of Spain on the facts, they used the judgment to do something huge. You should always attach this case to the definition of erga omnes, because it has officially introduced the concept to the court, proving that, for fundamental rights, standing expands to the whole international community, way beyond basic bilateral treaties.
And our last major one, the nuclear test cases between Australia, New Zealand, and France. France was conducting atmospheric nuclear tests, but their president and defense minister came out and publicly announced they would stop. Australia and New Zealand still wanted a formal court judgment to be sure. But the ICJ basically said, no, those public statements were enough. When your exam asks you about alternative sources, use this case. It proves that a simple, unilateral public declaration, if made with a clear intent to be bound, instantly creates real, enforceable legal obligations.
Okay, take a good look at this synthesis matrix. Seriously, if you can, take a mental picture right now. This is your ultimate study cheat sheet. It maps the doctrinal source of law right to its core legal element, and then straight to the exact landmark case you need to drop in your answer. If you can confidently recreate this framework in your exam essays, you are going to demonstrate a master-level understanding of how the whole theoretical framework of Article 38 operates out there in actual global jurisprudence.
As you wrap up your prep and get these elements memorized, I want you to keep this powerful quote from the U.S. Supreme Court in the Paquete Habana case in mind. International law is part of our law. We started off by asking how any of this works without a global parliament. Well, the answer is through this incredible, cohesive legal network of treaties, evolving custom, fundamental principles, and unilateral acts. It really makes you wonder, doesn't it? How do these totally invisible global rules actively shape the reality, the security, and the human rights that we rely on every single day? Good luck with your exams, everyone, and keep questioning the framework of our world.